Hello everyone, I'm Debojit Das and this is LiveLaw Daily. August 25th is observed as Balidan Divas by Gorkhas across India, marking the martyrdom of Major Durga Mal. A Gorkha soldier of the Indian National Army, Major Mal was hanged on this day in 1944 for his role in the struggle for India's independence. On that note, let's take a look at the biggest legal developments making news today. For our first story, the Calcutta High Court has asked the West Bengal police to provide details of all FIRs registered against Sumit Roy, the personal secretary of TMC National General Secretary and Diamond Harbour Member of Parliament Abhishek Banerjee. Sumit Roy has approached the High Court challenging FIRs linked to allegations of recruitment irregularities and a land-related case. He is also facing 4 other FIRs registered at different police stations in the state. During Monday's hearing, Senior Advocate Vikas Pehwa, appearing for Sumit Roy, told the court that several more FIRs had been registered against his client and alleged that FIRs were being lodged against him almost every day. Pehwa also submitted that Roy had been cooperating with the investigation and had appeared before the investigating agency 8 times. Justice Saugat Bhattacharya has now directed the police to submit a written report setting out the total number of FIRs registered against Sumit Roy. The court also deferred the matter to September 10th and indicated that no coercive action should be taken against Roy in the meantime. He has, however, been given liberty to approach the court if the police take any action against him. Sumit Roy had earlier secured protection from coercive action in the recruitment-related case, while his plea for similar protection in the land case was rejected. He then approached the Supreme Court and obtained interim protection. The Supreme Court is expected to hear that matter on August 31st. So for now, the Calcutta High Court wants a complete picture of the cases registered against Sumit Roy before it proceeds further with this plea. And for our second story today, there's fresh development in the student protest violence case before the Supreme Court, with some petitioners now raising concerns about the committee that the Supreme Court itself had appointed to look into the matter. Last week, the Supreme Court constituted a 5-member committee to examine allegations of police violence and vandalism by protesters. The committee is headed by former Supreme Court Judge Justice R. Subhash Reddy, along with former Punjab and Haryana High Court Chief Justice Ravi Shankar Jha, former Delhi High Court Judge Justice Shailendra Kaur, former CBI Director Rishi Kumar Shukla, and retired Meghalaya DGP Dr. L.R. Bishnoi. Now, Senior Advocate Gopal Shankar Narayanan, appearing for some petitioners, sought an early listing of an application concerning the committee. Solicitor General Tushar Mehta opposed this request, calling it a mischievous application and saying that the petitioners were seeking to reconstitute the committee and investigate ministers. He said, "This is not a political platform. They have given names of judges." Chief Justice of India Suryakant then said, "We don't appreciate mentioning of judges' names." Shankar Narayanan clarified that he had not submitted anything regarding judges' names and assured the court that none would be mentioned even if this application was listed. Advocate Prashant Bhushan, appearing for another group of petitioners, supported this application, saying it reflected a common concern and that the petitioners had misgivings about the committee. The Solicitor General responded that some parties have perennial misgivings about everything. The Chief Justice of India, however, said that the court had chosen the best available persons and that the committee would function under the Supreme Court's supervision. The court has agreed to list the application, so the concerns over the committee will now be considered further. For our third story, a public interest litigation has been filed in the Bombay High Court challenging Maharashtra's decision to make knowledge of Marathi a requirement for autorickshaw, taxi and app-based cab drivers. The petition has been filed by 4 Uber drivers against the state government's August 12th notification. The petitioners argued that the rule could discriminate against people from other parts of India who come to Maharashtra to work. They say it affects their right to move freely, reside and work anywhere in the country, as well as their right to equality. And there is a serious livelihood concern here. Under the new rules, if an RTO officer finds that a driver does not have the required working knowledge of Marathi, the driver's license can initially be suspended for 3 months and eventually cancelled. The Marathi requirement also applies when permits are issued or renewed. The petitioners say that many drivers are migrants, including from Uttar Pradesh, and depend entirely on driving for their livelihood. They have also cited a report which said that on the first day of implementation, 522 autorickshaw drivers were checked in Vasai Virar and 61 of them were issued notices warning of license suspension. The public interest litigation also relies on a 2017 Bombay High Court judgment, which had struck down an earlier rule making Marathi compulsory for autorickshaw permits. The petitioners are not opposing the promotion of Marathi, but their argument is that a language requirement should not become a barrier to earning a livelihood. The public interest litigation is likely to be mentioned before Acting Chief Justice Ravindra Goghe. For our next story, the Supreme Court has refused to interfere with the demolition of lawyers' chambers allegedly built by encroaching on public land near the Lucknow District Court complex. A bench of Justice Vikram Nath and Justice Sandeep Mehta dismissed a plea by the Central Bar Association of Lucknow challenging the Allahabad High Court's directions to issue demolition notices to alleged encroachers. During the hearing, Justice Nath questioned why the structures had been allowed to come up on the main road, and he was particularly clear that being a member or office bearer of a bar association cannot protect an unauthorized construction. You indulge in unauthorized construction and then you say, I'm elected as president of the association and therefore I have a right to continue. All demolitions have to take place, he said. The case concerns around 72 alleged encroachers, most of them advocates, whose chambers and structures were allegedly constructed over public pathways or public utility land. The High Court had directed the Lucknow Municipal Corporation to issue notices, giving the occupants an opportunity to either vacate or establish a lawful claim over the land. If they could not, demolition was to follow. During the Supreme Court hearing, senior advocate Adish Agrawal suggested that alternative space could be provided to the lawyers and also proposed mediation. Justice Nath questioned whether mediation was appropriate in a dispute involving alleged encroachers by lawyers. The bench also stressed that court premises themselves must be protected from encroachment. Justice Nath himself recalled seeing roads around the court premises being obstructed during his time as a High Court judge. The Supreme Court has now dismissed the challenge, leaving the Allahabad High Court's directions in place. For our next story, there's another anti-defection dispute before the Supreme Court, and this time it involves 20 Trinamool Congress members of Parliament who have sought recognition as a separate group in the Lok Sabha. The question before the court is, how long can disqualification proceedings be allowed to continue? The dispute began after these 20 members of parliament sought to break away from the TMC parliamentary party and align themselves with the Nationalist Citizens Party of India, or NCPI. The Trinamool Congress says that the members of parliament were elected on its symbol and that their move attracts the anti-defection law. The matter came up before a bench of Chief Justice of India Suryakant, Justice Joy Mallya Bagchi, and Justice V. Mohana on a petition filed by TMC General Secretary Abhishek Banerjee. Banerjee is seeking an expeditious decision from Lok Sabha Speaker Om Birla on the disqualification petitions filed against the 20 members of parliament. During the hearing, Solicitor General Tushar Mehta told the court that the Speaker had already issued notices to the rebel members of parliament. But Justice Bagchi pointed out, it is not a question of issuing notices. It is a question of concluding the proceedings within a time frame. The Supreme Court has now issued notice to the 20 members of parliament. The Speaker has also allotted them separate seating arrangements in the Lok Sabha. So the focus before the Supreme Court is now not just on the disqualification petitions, but on how quickly the Speaker should decide them. For our next story today, the Supreme Court today examined some striking numbers emerging from the West Bengal Special Intensive Revision, or SIR, of electoral rolls. A bench of Chief Justice of India Suryakant, Justice Joy Mallya Bagchi, and Justice V. Mohana was told that out of around 38 lakh appeals pending before the SIR appellate tribunals, nearly 31 lakh, that is around 80%, challenged the inclusion of people in the electoral rolls. Senior advocate Gopal Shankar Narayanan, citing an RTI response, said only around 7 lakh appeals had been filed by people challenging their own exclusion. He also pointed out that out of around 83,000 exclusion appeals already decided, more than 75,000 resulted in the voters being included. He suggested that tribunals should prioritize appeals filed by people who have been excluded, particularly with the Kolkata and Howrah municipal elections expected in December. There was another significant submission, and this time it was by senior advocate Kalyan Bondopadhyay, appearing for a TMC member. He said that in 31 constituencies, the BJP's winning margin was smaller than the number of voters deleted from the rolls. In one constituency, he said that the winning margin was 401 votes, while 8,785 voters had been deleted. The Chief Justice of India asked whether the court could direct fresh elections. Justice Bagchi, however, wanted to know how many of those deleted voters had actually challenged their exclusion. The court said it would examine the entire pending appeals and ensure that they are disposed of in time. And for our next story today, there's been a fresh development in the case involving journalist Abhishek Upadhyay, who had reported allegations of irregularities in donations to the Ram Mandir in Ayodhya. The Supreme Court has now heard his challenge to a Ghaziabad FIR, with his lawyer raising concerns about the way investigation is being carried out. A bench of Chief Justice of India Suryakant, Justice Joy Malia Bagchi, and Justice V. Mohana heard the matter. Senior advocate Pradeep Rai, appearing for Upadhyay, said his client's unpardonable sin was exposing the alleged Ayodhya donation scam apart from reporting on other alleged scams. He sought an investigation by an independent agency and also submitted that Upadhyay had not been supplied a complete copy of the FIR. Upadhyay has disputed the allegations arising from an alleged road rage incident near Shipra Mall. His plea points to a discrepancy in the FIR, which refers to a Splendor motorcycle, while the registration number mentioned allegedly belongs to another vehicle. He has also alleged that the police personnel approached shops near the spot of the incident and pressured shopkeepers to delete or withhold CCTV footage. He wants electronic evidence to be preserved. Another allegation concerns a police team of around 12 personnel visiting his home at night of August 20th, when Upadhyay was away and his wife and 2 daughters were reportedly at home. The Chief Justice of India acknowledged his apprehension, saying, "We appreciate your imminent apprehension because of repeated FIRs." The court asked Upadhyay to approach the High Court for quashing of the FIR while indicating that interim protection could be granted in the meantime. The matter will now continue before the appropriate forum. For our next story today, the Madras High Court has warned that it could impose costs on Tamil Nadu Chief Minister Joseph Vijay and Minister Aadhav Arjuna for seeking more time to file applications challenging the maintainability of election petitions against them. Justice V. Lakshmi Narayanan made it clear that the court was concerned about the delay because election petitions are required to be decided within 6 months. The court remarked, "I'm not bothered about the personalities. You people say that election cases are not being decided, but then you are asking for time." Vijay and Arjun had earlier told the court that they intended to file applications seeking rejection of election petitions. Their counsel said that the applications were ready, but signatures had been delayed because of the ongoing assembly session. The counsel assured the court that the applications would be filed shortly. Taking this assurance into court, the court refrained from imposing costs for now and adjourned the matter to August 27th. The court had admitted the election petitions in July, challenging Vijay's victories from Perambur and Tiruchirappalli East, as well as Arjun's victory from Vilivakkam in the 2026 assembly elections. There are currently 4 petitions against Vijay and 2 against Arjun. The court had earlier stressed that these election petitions must be decided expeditiously and within the statutory 6-month period. And finally, the Supreme Court today directed former Tehelka editor-in-chief Tarun Tejpal to surrender within 2 weeks before it hears his appeal against his conviction in the 2013 rape case. Justice Alok Aradhe rejected Tejpal's plea that his appeal could be heard without him first surrendering. Senior advocate Kapil Sibal, appearing for Tejpal, had argued that the Bombay High Court had already granted him 4 weeks' time to surrender when it convicted him and sentenced him on August 6th. Solicitor General Tushar Mehta, appearing for Goa, opposed this, submitting that the appeal could not be heard on merits unless Tejpal surrendered or obtained an exemption from surrender. The Bombay High Court's Goa bench had on August 6th overturned Tejpal's 2021 acquittal by the trial court and convicted him in the case, sentencing him to 10 years rigorous imprisonment. The case relates to allegations that Tejpal sexually assaulted a junior colleague inside a hotel elevator in Goa of November 2013. During an event organized by Tehelka. The High Court had imposed the minimum sentence prescribed for the offence, noting that the incident was 13 years old and that there was no report of any subsequent criminal misconduct by Tejpal. Meanwhile, the Goa government has also approached the Supreme Court seeking enhancement of the sentence to life imprisonment while not challenging the finding of conviction. For now, the Supreme Court has made one thing clear, and that is Tejpal must first surrender within 2 weeks before his appeal can be considered on merits. And that's all for today's LiveLaw Daily episode. If you found this useful, visit livelaw.in for more updates, subscribe to LiveLaw, and share this episode with someone who follows the courts. We'll be back tomorrow with more updates.